Welcome to Coffee Talk with immigration attorney and estate attorney Brian D. Lerner. I'm here to talk this particular video about what is known as the durable power of attorney. What is that? When does it come into play? Well, the durable power of attorney comes into play when you or your spouse become incapacitated. Okay. And I've done other videos on what exactly is the definition of being incapacitated. But for all intents purposes, you can think of it pretty much as a condition. Your medical condition makes it so that you cannot respond to any questions, that you cannot understand what is going on, that you are unconscious for either a temporary period of time or a more lengthy period of time. Now, the incapacity doesn't mean by any stretch of the imagination that you're guaranteed to essentially first become incapacitated and then die. There are situations where you become incapacitated for a period of time and then you recover and you are no longer incapacitated. And during that time, when you're incapacitated, the durable power of attorney comes into effect. Now, the durable power of attorney has nothing to do with after you have died or after your spouse has died. Okay, the durable power of attorney is only for the period of time in which you are incapacitated. So, what exactly is that? When you are incapacitated and you cannot make decisions on your by yourself, um, you do have financial matters to take care of. Okay, that's just a reality. The mortgage has to get paid. The utilities have to get paid. There's bank accounts with money that needs to be transferred from one place to another. There's bills. Everybody knows it. You know how much you do in a month regarding that. And what if all of a sudden you couldn't do it? What would happen? Well, during the incapacity, assuming you have had this properly prepared, an agent will be designated in which to be the one to carry out the durable power of attorney. Now, I already did a video on the Advanced Healthcare Directive, is where an agent can make the medical decisions for you. Many times, it's wise to put the same person in both of these processes. One, to make the same agent for the durable power of attorney, and then to make the same agent for the healthcare directive. And by doing that, you are able to essentially streamline what needs to be done to minimize the conflicts. But of course, the agent who's doing this has to agree to do it. You want to discuss this with them before and not have it, you know, pop onto them out of some surprise, because they either will have no clue what to do, or they'll have no idea that they were designated as an agent. So make sure the person can do it, is willing to do it, and able to do it. Okay. Now, the durable power of attorney for financial management typically will authorize the agent to engage in all types of arm's length transactions with respect to the principal's property. Now, the principal, of course, is used, the person who is incapacitated at the time that is necessary for the agent to make those decisions. Now, an agent may be given the power to make gifts to certain individuals and charitable organizations. Okay, it's wide open. You can make the durable power of attorney very narrow, or you can make it very wide. You can make it so it lasts considerably longer than you might think, or less. And that's why it's called durable power of attorney, because even after you can make decisions yourself, that's when it kicks in, really. That's when the event is triggered for you to have an agent make your financial decisions. Now, if you have established a revocable living trust, generally, the agent should be authorized to transfer your property into the trust after which the property would be managed by the trustee under the terms of the trust instrument. Now, that may sound a little complicated, but if you set it up right, the reality is your property will already be in the trust before you become incapacitated. But not everybody does that. Not everybody sets it up right or gets it right, or sometimes they set it up right and then 5 years later they buy some more property, except they don't put it in the trust. So, if you become incapacitated, it is possible for the agent, if given the authority, to move that property into the trust as designated. Now, if the principal, which would be, again, the person incapacitated, has not established a revocable trust, then the agent can even be authorized to establish one. I personally wouldn't recommend that you wait until you're incapacitated to have some agent establish a revocable trust. You really want to do that before you become incapacitated. But just in case, it is a good idea to have the clause if you hadn't, so that for estate purposes, should you die, at least you'll have the benefits of having a trust rather than it going through probate. Okay. Um, so, the trust itself, of course, would designate the beneficiaries and who goes to what. But at least by doing these types of decisions, if you can avoid probate, it most of the time is well worth it to avoid it. Now, the durable power of attorney can also be an instrument to avoid the need for court supervised conservatorship of the estate. Okay, but what that means is if there's nobody to make the decisions for the estate. Now we're talking now about the financial decisions, and nobody's been nominated in any way through the instrument. Then the court has to step in through probate proceedings and nominate a conservator to do it. And it may be somebody you know, it may be somebody you don't know, it may be somebody you don't like, it may be somebody you would never in a million years pick to be the conservator, maybe somebody who you haven't talked to in 20 years. So the moral of that story is prepare the durable power of attorney while you're not incapacitated and while you're able to do it, so you don't have to think about or deal with those issues. And more importantly, nobody else has to either. You do the durable power of attorney, tell who the agent's going to be, confirm with the agent it's okay, give the proper powers, and then things will go fairly smoothly. So the durable power of attorney can also make personal care decisions as may be appropriate for the elderly or disabled. And we're talking about, again, financial decisions, which would deal with, the principal's personal residence or other personal matters, dealing with property, checking accounts, financial matters that may come up in the future. So again, it can be quite broad as to what it does and doesn't allow. And again, it can fill the gap between when the person would become incapacitated and when they might die. And again, I want to stress, you might become incapacitated and then recover, at which point, the durable power of attorney would end, assuming that it is what you had wanted. So, given that, there's lots of benefits to doing a durable power of attorney and making sure it's done the proper way in the proper time. So if you like the video, click subscribe, click like, and then go ahead and give me a call or send an email regarding any questions you have. The initial consultation is free, and then I can help you from there. Okay, more on the coming videos.